Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. It has been 10 years since equitable distribution has become a law in the state. Today we'll look at its impact and see if it has made divorce more equal for women. We're also going to talk about the Child Support Standards Act legislation that has recently passed. Our guests are the Honorable Phyllis Gangle-Jacob, Acting Supreme Court Justice, New York County, and Myrna Felder. Myrna is a member of the firm of Raoul Lionel Felder and past president of the New York Women's Bar Association. Myrna specializes in matrimonial law. Hello, Judge Gangle-Jacob.
Hello.
Myrna.
Hello.
Judge, can you tell me what is the Child Support Standards Act?
Well, this is a recently enacted piece of legislation that was a very long time coming in New York State. It existed in other states. It was mandated, in fact, by the federal government. And in New York State, we now have standards by which the courts will set support for children, so that we don't have so many variables from judge to judge. Given the same set of or similar circumstances, you'll have much more consistency. You'll have better support for children. It will raise the standard of living of children.
Are these guidelines, or the court must follow it?
The court has some discretion within the parameters of the law. The law actually sets forth specific percentages based on the income of the non-custodial parent and the custodial parent. Those guidelines or standards, I think standards is a better word than guidelines, and that in fact is what the law is called, the Child Support Standards Act. Those standards are to be employed by the court unless there are special circumstances where justice would require that there be a variation.
Myrna, what are we talking about?
We're talking about children getting awards for the first time, or I shouldn't say for the first time, generally, which really approximate what it costs to raise a child.
I understand, but give us some examples. If a man makes $100,000 a year...
Well, I wish you had given a different example, because the Act has what's called a cap of $80,000. In other words, the automatic percentages, if you're going to apply them, if there are no special circumstances where a court is going to say...
The average case.
Right. I'm going to apply the percentages. If a man makes $80,000, for example, and a woman makes $0, and let's assume the woman is the custodial parent.
Okay.
There's 17% of total income if it's one child, 25% if it's two children, 29 if it's 3, 31 if it's 4, and 35% if it's 5 children.
Well, let's take if it's 2 children, it's 25%. That's obviously $20,000. That was easy.
Yes, there are some deductions, but basically that's it, yes.
And that's of his gross income, but the gentleman would have to pay taxes from that, wouldn't he, to the federal government, state, and city?
Correct. What this is based on is studies that were done across the country of how much it actually costs to raise children. And the days when we used to go into court and get support for a child with an $80,000 earner of $75 a week or $150 a week, which did little more than really put food on the table for the child or perhaps buy some clothing, are gone, because what was happening was that the children were suffering a radically depressed standard of living with this mother, because the award did not approximate what it really cost to raise the child.
Judge, of course, that's an example, the $80,000. But would that apply? Are there different examples if a man makes $50,000 and $40,000?
Well, it would be a percentage. And by the way, although we don't deduct federal or state taxes, if you reside in the city of New York, we do deduct the city taxes so that a resident of the city of New York doesn't have a greater burden than, as an example, somebody in Westchester. However, although generally speaking, the guidelines apply up to $80,000, they also apply beyond $80,000, but at the discretion of the court. So the mandate is not as explicit, but the court certainly will take into consideration income over $80,000. So I don't want anyone where there's income over $80,000 to think that they're relegated
To the
or
25%
limited
for 2 children?
to 25% of $80,000.
Well, has it been your experience that most judges are at least staying to the guidelines within certain degrees? If a man makes $100,000 or $125,000, how have the decisions been coming down?
Well, there haven't been too many decisions thus far, but those decisions that I've seen certainly do apply the guidelines. And when the income is above $80,000, that income is taken into consideration as well. You can imagine in that rare case where the father's income is $500,000 a year that you're not going to allocate, or you're unlikely, absent extraordinary circumstance, to allocate 25% of $500,000 for the support of 2 children. But if the father's income is $150,000, and if beyond the $80,000, you look at what the children's standard of living had been when the family was intact, what they were doing, how they lived, did they have tennis lessons and ice skating lessons and swimming lessons? Certainly you're going to provide enough additional money to keep the standard of living. By the way, the standards, that is the Act, also requires, in addition to the support percentage, additional add-ons for education, for medical needs, for child care expenses if the custodial parent is working or if the custodial parent is attending school, which will lead to employment.
Now, these are all in addition to the 20%.
Yes, sir.
25%.
Well, what happens if the non-custodial parent, of course it's usually the man and the woman stays home, but let's assume just the non-custodial parent, has debts and they've lived a very high lifestyle over the years, but he basically did that by borrowing on his credit cards and perhaps taking an equity mortgage on an apartment. What do they do then?
What the lawyer for that man has an opportunity to do under the statute is use those words to the judge. It's unfair and inappropriate to apply the percentages. Please give me an award under the general factors, which the statute does enumerate. So as the judge indicated, there is discretion in a case where it looks like it's going to create an injustice. For example, here is a debt-ridden man making $80,000, but the debt service, if it's legitimate, you know, we know a lot of husbands who, when they go into a matrimonial, you know, 6 months before they decide to get a divorce, they're quite wealthy and they have no debts. And there's a very small mortgage on this house. And then 6 months later, when they're getting ready to go to court, we have the fellow you gave us. But if it's legitimate, the court has the discretion to make an award factoring in these other things.
Judge, now in addition to the recommended award, in addition to the camp and all the other things that you mentioned, I assume there's also a position for maintenance for the non-custodial parent who's not working.
If there is, that is, if maintenance is set for the custodial parent. You're talking about the custodial parent who
yes,
is
the custodial parent. I get confused with
unemployed.
custodial and
Okay.
non-custodial.
Well, since in most cases it's the mother who's caring for the children, if the mother is unemployed and if she's entitled to maintenance, before doing the support standards percentages, we deduct the maintenance that the mother is getting. So that if indeed the father were earning $80,000 and the mother were earning $0, and maintenance to the mother was now $20,000, we would reduce the father's income to $60,000 before we took the 25%.
Marina, what happens in the case of, let's say, where the husband is a professional CPA, and in addition to paying maintenance, in addition to paying the child support, the court also awards a dollar amount for the man's practice.
You mean an equitable distribution?
Equitable distribution. And he has to pay that out. Is that taken into consideration as well?
Well, bear in mind that the court who is making the equitable award is also setting the child support guidelines, so that if, for example, there is the necessity for a payout, this is the very court who's going to consider whether it's unfair or inappropriate to go with the guidelines. But my suggestion to you is that you're trying to set up cases where it's going to be too onerous and too burdensome. What really is happening in most of the cases is we're getting closer to what's a really fair amount, to an amount that can be paid, can be afforded to be paid, and never was paid before because there weren't these standards that were set.
I'm going to ask Judge Gangle-Jacob that question right after this break. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
Lawyers, like medical specialists, limit their practice to certain areas of the law. At our firm, Zalman & Schnorman, we specialize in personal injury litigation. We concentrate on helping injury victims receive fair compensation, and there is no charge for our legal services unless we are successful. If you are too injured to come to our office, we will come to see you. At Zalman & Schnorman, we care about you.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all these lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, you're watching Lawline. Today's topic is matrimonial law and the recent changes in it. Today's guests are Judge Phyllis Gangle-Jacob and Myrna Felder. Judge Gangle-Jacob, excuse me. We were just talking about, are there agreements that you could opt out of this law?
Well, you know that most matrimonial cases, probably 99% of matrimonial cases, never come to court. I never get to review the agreement. And of course there are agreements which take care of equitable distribution of property, maintenance, support, custody, visitation, and that's how most cases are resolved. And that's where people have to be very careful with this new law. And I'll tell you why they have to be very careful. Because many lawyers are not as yet fully acquainted with the new law. Second, the client may be getting advice about this agreement, and they accept an agreement which gives them less than they're entitled to. Now, the new law tries to avoid this. It requires that when there's an agreement, it says that an agreement may be made to waive the provisions of the law. And that's sometimes appropriate. You get other trade-offs for that. But when that happens, the client is supposed to be informed about the law and is also supposed to know not just generally about the law, but the dollar amount that that custodial parent would be receiving if they didn't opt out, and the converse,
Right.
Myrna.
But don't you think this is one of the advantages of the law? Because when we used to try to get agreements, nobody, and the client would say to you, well, what do you think a court would give me? As we used to call it alimony, now it's maintenance, as child support. And you would say, it depends on the judge, it depends, who knows? Now you can say to a client, look, if you went to court, you would be getting X numbers of dollars as child support. Your husband says he wants to give me money for the money for the practice, etc. Instead, and he'll do this, that, and the other thing. You have an actual dollar amount you can work
Is this
with.
law retroactive?
That's a very interesting question. I've heard so
What
much
about actions
discussion on
pending
this.
now?
This
Actions
nobody
pending
knows
now,
this for sure.
definitely.
Yes.
Old agreements. Let's talk about old agreements. You can always, with respect to child support, traditionally, child support agreements could be reevaluated based on a substantial change of circumstance. Now, too, child support agreements can be reevaluated based on a substantial change of circumstance. And then the new guidelines can be, or standards could be applied. However, and must be applied once there's an opening. However, at the moment it would appear that there has to be a substantial change of circumstance. The mere change in the law is not sufficient for a review, but I understand that that's being changed, so people should be alert to other legislative changes, that there may be a legislative change which will permit a review even in those cases where there is not otherwise a substantial change
When
of
we're talking about a
circumstance.
review, would that be as well as an upward modification or a downward modification to go in the guidelines of
Do you
the law?
see the problem in the statute? It's this. What happens if I did my agreement on August 15, 1989? This act became effective September 15, 1989, okay? And instead of my receiving my 25% for my two children, which would be $500 a week, I'm receiving $325. I call up my lawyer. I say, a summons is coming, honey. No.
You better get your own lawyer.
Yeah, you get your own negligence lawyer. No, you call up and you say, look, I understand I'm entitled to $500 a week. Can I go back to court and open this up? And it creates a tremendous problem. The statute as it reads now is very strange. It says if you can show a change of circumstance, in other words, the key to the courthouse you used to have to come back in, once you're there, the court is free to say, well, wait a minute, under the standards, this should be $500. You have to show the special circumstance. What Phyllis is indicating is that there may be further legislation passing which permits more ready review. The question is, will there be enough judges and enough parts?
Well, let me take
And
an
there's
example.
another problem, and there is a problem of equity. Sometimes these agreements should be opened up. Sometimes these are hard negotiated agreements. There are many, many trade-offs that aren't apparent from the four corners
Such as
of
equitable
the agreement.
distribution.
You know,
It can sometimes be something more subtle than
it's
that.
something much more subtle than that. Certain trade-offs that are never reflected in the agreement, and as to these old agreements, there will not have been the representation that the person knew about the standards, the representation that they knew how much they would get, and the representation that they opted out of them. So it's a problem.
Myrna, we have to take a break now, but I'd like to have you think about equitable distribution and how it differs from community property. Let's take a break
That's
now.
easy.
You're watching Law Line. Stay with us.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
If you are injured in an automobile or any type of accident, you have the right to fair compensation for injuries, pain, and suffering, including loss of wages. So if an accident leaves you disabled or unable to return to your job, put our law firm, Zalman & Schnorman, to work for you. There is no charge for our legal services unless your case is settled or won. Call Zalman & Schnorman, who is specialist in personal injury litigation.
My father, Gordon McCrae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Hi, you're watching Lawline. I'm Alan Schnorman, your host. Today's topic is matrimonial law. With us, we have Judge Phyllis Gangle-Jacob and Myrna Felder. Myrna, as I asked you before the break, tell us what equitable distribution is and what community property, which one do we have here?
Okay. We have equitable distribution. What you're describing are two different ways that a court can divide property. There actually are three different ways. What we used to have in New York before we had equitable distribution in 1980, when it was changed, was title. In other words, whoever held title to the property, that's how
If I
it's
accumulated the
divided.
most assets, I went
Right.
home with them.
And that's what usually happened with the men. They had the assets in their name. Maybe the house was in joint name or the car, but the IBM stock, the business, was usually in the more substantially wage earner or...
An equitable distribution?
An equitable distribution gives the court the discretion to do what's equitable, to distribute the marital property, that is, the property acquired during the marriage, in accordance with what's fair. Community property, which is our California style, and some other states, is the automatic 50-50 division of the marital property.
Judge, we just spoke about guidelines for support. Are there also guidelines for equitable distribution?
Yes, there are. There are factors that the court takes into consideration in making a determination of equitable distribution. Now, I will say that different judges do this different ways. I like to think that in most cases, I start off with the concept that marriage is an economic partnership, and I like to think of it as a 50-50 partnership. So I start off with the feeling that these people should share that which has been accumulated during the marriage. Of course, excluded from equitable distribution is inherited property and money that you came into the marriage with. But that which was accumulated, I like to think, is going to be divided 50-50, and then I apply factors which would make me move to 60-40, 55, whatever.
Judge, can I give you an example?
Yes.
What happens if I purchased a co-op years ago when I was single? And then I got married 2 or 3 years later, and since then the co-op has gone up $100,000. I paid a little money. Now,
how long are you married?
Now, this is just an example.
Oh, okay. How long?
Let's assume that
is
married
your
now
mythical
8 years.
8 years.
And
Almost a long-term marriage by today's standards.
Certainly a Manhattan success story. And I had the co-op for 2 years previous to that, but I purchased it with my own money. Now, does my spouse get any percentage of that increase?
How much money have you spent on decorating it in the past 8 years?
Well, of course, we've decorated it, and we've painted it, and we've kept it because we like a nice apartment.
And who's been doing all that decorating?
Let's assume that the couple did it together.
And
Am I being cross-examined today? I thought this is my show.
who's been paying the maintenance?
Well, we both worked, and we always jointly paid our monies together.
And was there a mortgage on the apartment?
Oh, yes, of course. There was financing that was originally taken out, and that came out of our joint monies.
Well, based on all of that, it's not exactly clear that you were the only one who paid for this apartment, right?
Well, let's assume in the example the person paid the down payment, and as I said, it was his apartment.
You know what you're verging on, of course, something that we haven't spoken about is, although what you bring into the marriage is accepted, there's an exception to that, and that is the extent to which what starts out as separate property appreciates through the efforts of either spouse,
Okay.
either direct or indirect.
Now, of course, that was an easy example because
well,
I
it's a more
said...
complicated example.
do you
In this
understand?
case, not only has it appreciated during the marriage, but in addition to that, it was paid for substantially during those 8 years by both spouses, although you may have put down the initial $20,000 deposit.
I better tell my wife we're happily married, if she's watching. Another example, let's take the same example, but this time make it IBM stock, which I purchased just 2 years before. I didn't add anything to it.
right?
But the stock in those 7 years or 8 years that I was married also appreciated.
Now you're verging on, you're a shill. He's trying to give us, a distinction has arisen in the law between active assets and passive assets. When you're dealing with property that someone brings into the marriage, and you're going to try to get a part of that appreciation, how it increases in value. If it's a passive asset, like IBM,
Right.
which rises just from market factors, it has nothing to do with either the person who has it or the other person.
Rises and falls from
yeah.
market
That's right. In that instance, so far, our courts have said the non-titled spouse can have no part of that appreciation because nothing of the efforts of either spouse had anything to do with the increase in value. As opposed to an active asset, which you decorate, paint, live in, and have
But let me just say as to your shares of stock. If indeed you go to work, you have these shares, you put them in the vault, they're sitting there, nobody spends too much time or energy attending to them, fine, then they're passive. You have another job. But let's say you have a whole box full of stock, and you're doing so well in your market investments that you leave your job and you're now devoting full time to trading shares of stock.
Well, then you're in
That's different. You're now in business.
Judge, my viewers are always wondering about lawyers' fees. They're always concerned about attorneys' fees. Now, let's assume
So are the attorneys.
That's right.
let's assume that the husband works, he has all the money, and the wife has nothing, but the marriage is breaking up. Now, she doesn't have the money to go out and spend on a lawyer. What can she do?
Well, our law is very clear that if the moneyed spouse is in a position to pay the legal fees of the non-moneyed spouse, the court will award them legal fees, what we call pendente lite, pending the litigation, before anything even starts. If you need money to get a lawyer, the first application your lawyer can make is for legal fees.
Marina, what if both husband and wife are both working?
Yes.
Do they pay their own legal fees, or is the wife still entitled to legal fees?
Bear in mind that there are really two stages in an equitable distribution litigation. The first is to enable a party to get to trial, so that if one party, even though working, has
You
less
have to answer
funds,
fast in the
they
moment we
can
have.
get it to the end. But at the end, if they divide everything equally, they're going to end up dividing the responsibility for fees because each will end up with half.
Judge Phyllis Gengel-Jacob, Marina Felder, thank you both for being on Law Line. We're certainly going to have you back. And this is Alan Schnorman, and as always, thank you for watching Law Line.
You have been watching Law Line with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Law Line, 27th floor, 63 Wall Street, New York, New York, 10005.